Quite an exciting moment to have you join on the fresh episode of Law and You. We took you around the journey last week on the rights of the accused and procedure. Today we're going to be having the flip side, which is on arrest, legal rights and procedures. And we're going to be looking at an attempt on making a definition of what arrest is, the rights of the apprehended, and what are the limitations. My name is Philip Omo Gyupo. Today we are being joined by a custodian of the law, Joshua Abolagba. Thanks for joining, Joshua.
Yeah, thank you very much.
All right, let's first of all attempt a definition of what arrest is and who are the law enforcement agents or the authorities in charge to apprehend anyone or any suspect in that regard. And let's look at the limitations.
Yeah, with regards to the arrest is, simply put, can be said to be the deprivation of someone's freedom of movement by a body saddled with that responsibility of doing so.
Okay.
With regards to talking about the arrest by a police officer who is a law officer, so the police can effect an arrest. With regards to matters bordering on financial impropriety and crime, the officers of the EFCC, Economic and Financial Crimes Commission, can effect an arrest. With regards to matters bordering on drug trafficking and drug peddling, the NDLEA, which is the body saddled with tackling drug crimes, can effect an arrest. And also, some persons don't even really know that the office of the citizen, as a private individual, can also effect an arrest.
Okay.
So on some certain occasions, yes.
Okay, when one is arrested, there's always this saying, which is common, that you have a right to remain silent, otherwise whatever you say may be used against you in the law court. Does that mean that at the point where one is arrested, by virtue of what is being said in that saying, that the suspect can keep quiet without saying anything, even to a point of not making any documentation until he gets a lawyer?
Yes, very true, very true. That's even most times what we even advise, as legal practitioners. If a client is arrested, you tell the client not to make any statements pending when he has a legal representation. And even the law expressly states that you have a right to remain silent, pending when you have your legal representative there with you, or the legal aid counsel provides a legal representative for you, where you cannot provide one for yourself. So you cannot be mandated to make any statements or put pen to paper with regards to any issue bordering on what you have been arrested for, till you have legal representative there before you can now be, put things down to paper, and then they explain, the crime for which you are being arrested for is now told to you, and then you are now made to now make explanation, but then the legal representative must be there.
Okay, well, let's look at a perspective where someone is arrested, for instance, and the person is not being tried within 48 hours, or the case is not being prosecuted to court. What are the provisions of the law as regards that?
Yeah, with regards to the prosecution, and charging to court, the law expressly states that a person who is accused of who is seen to be arrested and accused of committing an offense, has to be charged to court within 24 hours.
Oh, within 24 hours.
24 hours, whereby the court is within a 40-kilometer radius of the police station or the holding facility. And also, if it is not within 40-kilometer radius, then the law provides for a situation whereby a person can be charged within 48 hours.
Within 48 hours.
Yes.
So it's relative to the distance.
The distance which a person can be charged to court. And so, there's always that aspect of the law, the constitution, the criminal code, the application of criminal justice act, criminal justice law in Edo State, talking about protecting the liberty of the individual, because that's something that's expressly stated in the constitution, as a fundamental human right, that you have freedom of liberty. But then such, like what we always say, whereby the right is extended to a particular point in time, there is no right that is without limitation. And so whereby limitation comes in is whereby the person is arrested, and so he has to be charged for an offense that is codified. What we codified means, so it should be an offense that is known to law. So you cannot charge somebody to court or arrest somebody bordering on, quote unquote, an offense that is not known to law.
Okay. Yes. Well, quickly, let's situate this, that the program is brought to you courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. And the numbers writing on the screen is for you to ventilate your opinions. In what way have you been apprehended, or in what way have you been denied your rights? as regards the provisions of the law. You pouch your responses on the numbers writing on the screen, and that could also help us to form a next episode in order we are in the direction or perspective of critically your situations or the responses that you brought in. So please do that while you see the numbers on the screen. Let's look at a perspective where most times we always talk about the need for the apprehended not to be tortured.
Yes.
And we see in some cases where law enforcement agents go ahead to torture, their suspects that have been arrested. Is this according to the provisions of the law?
With regards to the torture, it must make cognizance to the Anti-Torture Act, which was promulgated in 2017. And that act specifically states expressly, clearly, and states that an individual should not be tortured on no account. So even if the torture is being carried out by the officer of the law, it is not right. And in such a situation whereby the person is tortured and is seen to actually be tortured unreasonably, then such a person can file for a suit on breach of fundamental human rights.
Okay.
And so it is expressly stated that even when you want to arrest someone, you should just tell the person. And then if the person now decides to, run or escape, that's when you can now cuff the person. So normally, you should not even cuff a suspect.
Oh.
Yes, except the person tries to run or make a run for it. That's when you can now use reasonable force. And so that's on that thing that comes in. So reasonable force. So you cannot just say because the person tried to run away, then instead of just trying to catch him or that, you just shoot him. No, that's not allowed. When with regards to the Anti-Torture Act, it talks about the fact that persons should not torture anyone. So even if you are an officer of the law or you are a layman, you don't have the right to torture anybody, because each and every individual in Nigeria has the right to liberty, personal liberty, as provided for in the Constitution, a fundamental right. So whereby that person's right is whereby someone is being tortured, it means the person's fundamental right has been breached upon.
Well, let's look at the aspect, because I know that one can be apprehended either for civil offenses or civil charges or for criminal charges. A situation where someone is arrested for criminal charges and there need to be some quizzing by the law enforcement agents in order to unwrap, statements that could also help in, getting to the right situation in terms of getting to the crux, and also getting others who are at large, for instance, in the case of armed robbery suspects. Are you saying that such rights also can be enjoyed?
Yes, such rights can also be enjoyed. That's what we always say with regards to, it should not be that just because this person was caught in the act or because this person is seen to be a criminal, then you can now torture a person. I must ask you a question also. If you say that they need to get information out of that person, so and so, but then again, it is only a court of competent jurisdiction that can actually pronounce somebody as guilty. So, if somebody is caught in the act, he's a suspect, and he remains a suspect till he is sentenced by court of competent jurisdiction for that crime.
We often have situations where it is difficult to get information from hardened criminals or suspects in that direction. And most times, practically, it's going to be a difficult task if, the law enforcement agents is denied of quizzing such, suspects in order for them to give out information leading to the investigation of those criminal acts as being suspected. So do you now say critically that such law enforcement agents go beyond their limits? And if they do, how then can they get information as regards dealing with investigating hardened criminals?
Yeah, with regards to that, the rights, you have the right to arrest, and so that arrest has been made. Then you have to charge the person to court. It is in court that that person can be grilled to get information, that would either lead to his acquittal or his remand in custody for such a crime. So you can't do that in a closed place. And that's why we also say that whereby someone is arrested, the law has expressly stated that he has a right to legal representation. So if the legal representative is there, they will even tell you, you have a right to remain silent. So if the law had already expressly stated that you have a right to remain silent, it therefore means that the law has the express mentioning of something to the exclusion of the others. So if the law expressly has stated that you have a right to remain silent, it means that on no account can you be quizzed beyond a reasonable extent just to get information? After all, the law has expressly stated that you can remain silent. So that means that and then also, with regards to criminal matters, the whole crux to prove beyond reasonable doubt is on the prosecution and not the accused. So the prosecution is the one that will go and get evidence to facilitate the matter.
How will the law enforcement agent get evidence when it's not able to investigate it properly to a point where some hardened criminal suspects should speak up or spill out in terms of getting those who are at large? Because we've seen situations where in robbery incidents, the law enforcement agents are able to get one and then others are at large. And are you saying that he's going to be in the courtroom for them to quiz such suspects before they can go investigating on those that are at large?
No, with regards to that, they can be quizzed even at the point of arrest or in the police station.
Exactly my point.
Yes, and
so if such a criminal suspect is failing to spill information leading to the arrest of those at large, are you saying that under normal circumstances or by the provisions of the law, such considerations are not given in order to get information in getting those at large arrested? Because this has to do with robbery cases where even the larger society is at risk of having such persons who are already mixed in the crowd, of also causing more uncomfortable situations for the general public. So are there no ways where the law can also provide such discretions to the law enforcement agents?
The law enforcement agents are empowered to get information and then make sure the person, or rather to an extent, tell the person to write down his statements, and then also to tell the person this is what you are accused of.
After all, you were caught in the act.
Yes, you were caught in the act, so this is what you have been accused of. But then again, even if you are caught in the act, you remain a suspect until you are proven guilty for criminal offense beyond reasonable doubt. So there are certain situations that can happen. Imagine someone that says he or she was caught in the act, but is a twin, and then it is the twin that was arrested, and then maybe they are just pursuing the person, and then the twin comes out and like, what's happening? And the other one has scaled the fence, and then we get the twin, and they were grilling the twin, and the twin is saying, I'm not the one. And they will keep saying, you must confess that you are the one. In such a situation, what happens? So these are the technicalities that the law has envisaged, so that you don't, it is better for, like what they say in law, it's better for 10 accused persons to be free than for one innocent person to be punished for what he has not done. So in such a situation, if you now say they must beat the person and bring out information from there, there are some certain situations in which some persons might be grieved and they find out that, okay, what is actually the punishment for this offense I've, quote unquote, be said to commit? They say it's a fine, option of fine 5,000 naira. And they say, yes, now me do one. So me they just leave me. So I'm the one that did, let them just leave me. Let me just go. It's not 5,000. But you're forgetting that once you have been convicted, even if it's for a very simple thing, you are an ex-convict. So when they wait, the person who has committed a very previous crime and you that has committed a crime, but two of you were convicted by a court of competent jurisdiction, you are both ex-convicts when you come outside. So such a situation is whereby the law tries as much as possible to ensure that persons are not grilled too much, because most times when they try to get statements out of these persons by utilizing force, then again sometimes the persons might just give up, like I earlier on said, and they say, let me just say it's me that said it, let me just rest, so that I can't continue like this. The torture is getting too much. And so that's what the Anti-Torture Act has come to check, so that we don't go about beating persons, and the persons are not scared of the police. The police is supposed to be our friend, are supposed to protect the masses. So if anybody knows that if I enter a police station, I'll be beaten till I confess to a crime that I didn't commit, then nobody will be willing to even report an incident to the police or even run to the police.
Okay.
Yes.
Well, in case you're just watching this Law and You and coming to you courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. And we are with the legal practitioner Joshua Abulagba. Let's stretch it a little bit further. Let's look at the aspect where some who fall in the bracket of the Gen Zs, who are usually interrogated by law enforcement agents when they intercept them, on the road, maybe while driving Porsche cars. They stop them and search their phones because they have dreadlocks and they have a look that gives an impression that they are into Yahoo and other aspects in that regard. Does the law provide that just on the look of the suspects, they can be interrogated to a point where they can also check their phones?
No, with regards to the checking of, the phones or gadgets of persons,
Okay.
the law states that you need a warrant to be able to do that. But the law also provides that whereby a police officer, in his own, in his own volition, feels that this person might be a criminal element or has the ability to constitute a crime, then he can, question the person.
At that point, without a search warrant?
Yes, you can question the person. And that's what they tell you, your particulars, your papers, your driving license, all those kind of things. So they can actually question you with regards to that.
To the point of checking your phones?
No,
Gadgets?
No, you don't check your gadgets without the warrant. Even
Because we've seen situations like that, even in buses, while embarking on journeys. Those law enforcement agents that mount roadblocks, they stop such buses and tell the occupants of such buses to come out while they search through their bags. Is it lawful to do that?
No, it's not. Without a warrant. And then even with a warrant, when you are searching a person, the person of a person, it has to be a man searching a man, a woman searching a woman. So even if you are a police officer and you want to conduct a search on the person of a female, you have to call on your colleague who is a female to conduct that search. You don't have a right to search a female.
You are painting two scenarios. At the point you said that they don't have a right to do that.
Yes,
But again, you are saying that even if they want to do that, even if you have a female officer to check the female passenger and that of the male to check the male. So which means to some extent they have discretionary rights to do that.
That's what if there's a crime being committed or a crime has been committed not long before that scenario, but on a normal day you need the warrant. But then again, even if the law also provides that even if there's no warrant, but due to the fact that there are extenuating circumstances or the circumstances on ground warrants you to make such search, then you can get the warrant subsequently. So it means that, for example, if an offense has been committed and then the police believes that these vehicles are passing, maybe one or two occupants could have entered into it and they are hiding from the crime scene, then in the operation, in the line of the duty, they can then make such search as just to ensure that the occupants there are not criminal elements. But then again, it must be within the ambit of the law, and you must have dignity for the person of the person whom you are searching.
So what you just said, that to some extent the police law enforcement agents have the right to do that if there are cases of criminal charges within that location.
Yes.
Okay.
Yes.
Now, but you left one unanswered. An aspect where, from the way the police officer will perceive those who are in the Gen Z group,
yes,
born from the age of 1997 to 2012, for instance, who are in the young generation group. Now, do they have the right to, just by virtue of appearance, search such persons? Does the law carry that?
No. I've earlier on clarified that you don't search the person of an individual
based on appearance.
Yes, based on appearance. No, you don't do that.
Okay.
Because it's just that in Nigeria, for example, when persons see people with keeping
dreadlocks,
hair, dreadlocks and those kind of things,
having a young look.
Yes, having a young look, you just believe that you are into criminal endeavors. But no, in some other jurisdictions, even legal officers keep dreadlock. They even have tattoos, just undercover, so you don't even know that these persons are officers of the law. But in Nigeria, because of the African culture, most times the Africanness is still there, and so most times when they see a man, for example, having dreadlocks or putting on earring, then automatically he's perceived to be a criminal element. But it's not supposed to be so. You don't judge persons based on their appearance.
Okay.
Because now we have seen even some persons who are of repute who keep their hair or keep afro, so because we know them that they are persons of repute, so you don't see them as criminal elements.
So the way you look shouldn't be judged.
No, it shouldn't be judged. Yeah, because
Yes,
after
you
all,
shouldn't be judged by the way you look.
yes, you shouldn't be. After all, those of us who watch movies, we have seen even drug dealers who will put on suit and put on tie, and then you think they're even bankers. So in such a situation, when you see such a person now, you might not even go there that the person is a criminal element.
Okay.
So, but what I also advise is that, in as much as we say the police should not, be too stringent with how they, see people or how they profile persons, but then again, we as youths also should try as possible to relate well with the police officers. Yes, when they stop, because if they stop you, bring your license and everything, and then you give them that and everything, at least to an extent, you are.
Or they stop you to search your bags.
No. They stop you to ask for what they are supposed to ask for, which is your license, your registration, and those kind of things. Then you should oblige them. Okay. It is when most times it degenerates from that. Nobody asks you, let me see your license, and you say, why will I give my license? And then another step out of the car, and then all those kind of things now.
Okay.
So most times, and I know sometimes you can even be friendly with them, and you can talk well, and then they will still, try to just get under your skin. But then again, if to a large extent they ask for some things, and then they ask for your license, particulars, and those kind of things, step out, let me check your boots and everything, and then you do that, then most times it doesn't degenerate to a situation whereby they will now start talking about your person and say, why are you keeping dread? Why are you putting on hearing?
Okay, please interact with us and interact to the conversation and send your responses via the numbers writing on the screen. It's Law and You, courtesy of Noah Attorneys, a firm of legal practitioners based in Benin City, Nigeria. Now, let's quiz more into the aspect of offenses committed to an individual, for instance, like what you said as regards based on appearance, one is being grilled unnecessarily, and situations like that, and also aspects where one is being tortured in the custody of the law enforcement agents. What are the retribution, or what are the punishment for such law enforcement agents when eventually they see in the law court that such persons that were being grilled were really innocent? Are there compensations made in that regard?
Yes, definitely there are compensations made. With regards to the aspect of being grilled, and then you find out that the person was not,
was actually innocent. But by this time around, the person has been tortured.
Tortured, yes,
and injuries inflicted.
Then the person, the officer who, brought about that torture, or who engaged in such a torture, would be liable both criminally and civil, under civil liability. Criminally, because you are torturing somebody. Then under civil liability, under the Police Act, you also be. So there will be sanctions both as a police officer, whereby you can be dismissed from the force, and then also there will be sanction from the court of justice for torturing an individual, a respectable person in the society.
Okay.
So there is punishment.
Okay. What about in the aspect of bails? Because we already know that by the provision of the law, bails are free; they are not charged. But we still have a situation where the law enforcement agents find a way to go around it and make the victims pay one way or the other. How do we nip this in the bud in that regard?
With regards to bail, they say it's a bailable offense, but then again there are some things that must be met, before such bail can be granted. So in such a situation, it's not really, making such, how will I put it, it's not really like making such payments for bail. For example, imagine someone that before bail can be granted needs a surety. Needs surety. Yes. Some likes of so and so amounts of money, or in like some, and has somebody that has properties in this particular place, or somebody that is a grade, something level.
For those who have flight risk, for instance.
Yes. So all these kind of things. Yeah. So in such a situation, the layman might just believe that a person was asked to pay so and so amount. But no, those things are put in place just to ensure that the person does not escape.
But that is done by the law court and not by the
law court. That's what we see.
Police officers.
That's what we see. If the matter is charged,
I'm talking about when it gets to the hands of the police officers, for instance, when one is being arrested and then bails are being granted and they are asked that they should pay for it. Is it lawful?
No. Bail is free. Okay. What you can do is only the courts that can give.
So you can't. So only
the courts.
All right, that can
actually give. Yes,
as regards bail.
With regards to bail, give the what they call it, like the what you ought to have gone through
Okay.
before such bail is granted. So only the court has the right. That's why I say that you must be charged within 24 to
All right.
48 hours.
Thank you so much, Joshua Bulagba, for taking our time to be part of this. We actually have not been able to exhaust all of this completely, but your interaction to the conversation will also help us to, pinpoint what will form the next episode on the program Law and You. I am Philip Omo Gupon. I see you on the next one. Goodbye.